Hello, I'm George Liston, CA. Welcome to Dialogue, a program that explores the world of ideas and issues in international affairs, history, and culture. Arguably, the two most definitive political rituals in America are the quadrennial election of presidents and the periodic selection of Supreme Court justices. Now, presidential campaigns engage the popular passion of a vast electorate and render a precise reading of the national mood. The selection of candidates for our highest court is the responsibility of a president, whose choice must gain the confirmation of the United States Senate. It's often a long, intense process whose outcome involves a painstaking examination of the principal arguments in American judicial philosophy. As the nation debates its political future in a remarkable presidential campaign, it's important to remember that the composition of the Supreme Court will also have a great deal to say about the evolution of American democracy. My guest is Joan Biskupic, Supreme Court correspondent for USA Today and author of Sandra Day O'Connor, How the First Woman on the Supreme Court Became Its Most Influential Justice. Joan, welcome to Dialogue.
Thank you, George.
I know you're currently working on a biography of Justice Scalia, are you not?
That's right.
It's something to look forward to. The O'Connor book was fantastic.
Thank you.
We've got the right person, so here's a starting question, Joan. Senator John McCain is on record as having said earlier this year in the campaign that, and I quote, the question of Supreme Court nominations is a defining issue in the presidential election. And I'm absolutely certain there'd be bipartisan agreement that Senator Barack Obama would agree with that. But it does strike me, Joan, and this is the question, that they have maybe they have similar or dissimilar prospects in terms of what that might mean in terms of each man and the choices they would be faced with. I mean, to be very blunt about it, it looks to me like the liberal wing of the court may demographically have characteristics that, present Obama with choices that McCain might not have, and McCain might numerically be able to do things that Obama can't do, but you tell me.
That's right. First of all, both of our presidential candidates are exactly right that it's an extremely consequential question ahead of both of them, who would be next for the Supreme Court. The Supreme Court essentially is locked in a 5-4 pattern on some of the biggest cases: abortion rights, racial remedies and government policy, division of church-state, campaign finance reform. Exactly. So these are all very close cases, and neither side prevails all the time, the conservative wing or the liberal wing. But to get to your key question about who might be able to make the most difference, it has to do with who will leave.
Exactly.
And right now, our most senior members, the eldest members, are all the more liberal jurists on the court. Justice John Paul Stevens is 88. He shows no sign of wanting to leave the bench, but when you're 88, certainly that's a consideration. Justice Ruth Bader Ginsburg, currently the only female on the Supreme Court, is 75 now. And so the two of them are the more liberals on the court, and if either of them were to go first and Barack Obama had the appointment, if he won the election, essentially it would be a wash, a liberal for a liberal. But if John McCain wins the election and is able to appoint the successor to either of those two jurists, that would tip the court more to the right. After that, we have three others who are in their 70s. One, Stephen Breyer, who was also a Clinton appointee, like Ruth Bader Ginsburg was, and then the other two are both 72 years old, Antonin Scalia and Anthony Kennedy. But I think it's the two more senior liberals that everybody's had their eye on.
Boy, that's fascinating. I love the way you give your answers, Joan. That is immediately comprehensible, and people can get a sense of just how immediate all these questions might be. Is, just out of curiosity, is Justice Roberts, the Chief Justice, the youngest?
Yes, he is. He is the youngest. He's 53 years old. Then comes Samuel Alito, who's, if I remember right, he was born April 1st, 1950. So he's still in his 50s himself. Justice Clarence Thomas, who came on as a very young man at age 43, just turned 60 this year in June. So those three are our youngest. And then David Souter will turn 70 in about a year and a half, 2 years.
You know, Joan, it strikes me just this very moment as I listen to you that the joker in the deck, so to speak, is we're talking about, this is why I love being an English major, human motives and unpredictability of fate. In this sense, we're talking about, well, the numerical question, the statistical question, as you pointed out, is pretty clear. But when these justices get chosen by whichever president chooses them, it's because they have certain expectations of how they'll behave. But that doesn't always bear out in fact, does it?
It doesn't. And the other thing is, presidents tend to want to choose somebody who's younger, and Republicans who have had quite a track record with the Supreme Court and the lower courts have tended to go for younger nominees as opposed to what the Democrats have gone for, and that's also in the mix. So as the president is looking at who he might choose, he's looking at who's being replaced, what the individual candidates' track records were, and their age and several other factors, what constituencies they would like to play to, because after all, it is a political choice.
Exactly.
And you asked, does it usually turn out the way they want it to turn out? Well, we've got two Republican appointees in recent years who didn't turn out the way the president sought.
Is Justice Souter one of them?
Justice Souter would be one of them, that's right. Justice Souter was nominated by the first President Bush in 1990 to succeed William Brennan, the legendary William Brennan, who was a really bulwark for individual liberties. He was former Chief Justice Earl Warren's right-hand man in developing the strategies to end school segregation, the strategies on many, many important civil rights and criminal defendants questions. And David Souter was chosen as a New Hampshire jurist, had been recommended by several Republican partisans. If you remember John Sununu, who was the first President Bush's chief of staff, he said it's a home run for conservatives. Well, lo and behold, David Souter, if you listened carefully to his confirmation hearings, you would have known that he wasn't going to be as conservative as some people predicted. And then the truth is, he formed quite a bond with William Brennan, and that's why I mentioned Justice Brennan's record, and the two became friends while Justice Brennan was still living. And today, you would definitely characterize Justice Souter as much more of a liberal than a conservative. And the other person I was going to mention before that is Richard Nixon's appointment of Harry Blackmun, who comes from this very Republican conservative president. At the time he was that. Now he looks almost liberal compared to George W. Bush. But Harry Blackmun gives us Roe versus Wade, the 1973 decision that made abortion legal nationwide.
We're going to come back to that, particularly as we discuss who might be in consideration on both sides, but that's a wonderful point to make. The obvious question flowing from this part of our conversation, Joan, is what will the court itself face as a group as it convenes on the famous first Monday of October.
Right, and we're coming up on the first Monday.
We are approaching it fast, and I've done my little bit of homework, and it seems to me there are perennial questions and the ones that add to it, but the docket is much, or the possibility of that docket strikes me as being much broader than just Roe versus Wade.
Oh, very much so. Very much so. In fact, some of your viewers might be familiar with one of the highest profile cases the justices already have decided to take up, and that has to do with the federal communications policy of banning one-time expletives on TV shows.
Oh, I heard about,
this is the one where Cher and Nicole Richie and Bono, all in various acceptance speeches at either the Golden Globes or the Billboard Awards, made remarks that, as they're termed in the law, fleeting expletives. And the question is, should the FCC be able to sanction those one-time use of swear words, of bad words? And it's a bit of a procedural question coming before the justices in terms of how to assess this question that a lot of people would consider related to the First Amendment, although the core First Amendment question is not now before the justices. But it is a rather sexy question of what government regulators can do about about these celebrities who stand up here at the microphone and on live TV utter these words.
Right.
So the justices will be looking at that question. They also have a question having to do with the Navy's use of sonar training exercises off the California coast.
Is that an animal rights issue? I mean, protecting marine wildlife?
It's more, at bottom, it is very much of a concern about marine wildlife and what it does to the whales and dolphins there. But a lot of these questions actually, even though they implicate these important social issues, have to do with technical legal disputes between regulatory powers of the executive and or state authority versus federal authority. So I won't bore you with the intricacy of the question presented in these cases, but yet tell you that there are a lot of big cases both at the court right now and percolating back up to the Supreme Court from lower courts that will really make a difference in the area of free speech, in the area of marine life protection. And then there's one that has not been accepted yet, but that I believe the justices will look at, involving the reauthorization of federal voting rights law. So we have a real, as you say, it's not just a court that will look at the predictable questions of abortion rights or affirmative action. There's a real swath of legal landscape that the justices will cross over the next 9 months.
There seems to be a lot of social values questions involved in these issues. For example, Joan, I've heard that, or is it correct that support for religious schools may come up as well?
Well, that's a perennial question. We have right now a religion speech case on the docket involving a religion from Park City, Utah, I believe, where they wanted to erect a monument in the town square, and the question was whether this non-traditional group should have the same right as other groups have to put up a religiously inspired monument. Right. So we've got all sorts of questions like that coming up. And you mentioned the values question. The justices themselves constantly say, oh, we're not holding our fingers up to the wind to see where social values are prevailing. But when it comes right down to it, a lot of these questions do, for viewers and for the participants in cases at the court, go to what kinds of values will be carried out in the law.
I'm really glad to hear you say, as I said in the introduction, the presidential election, in one sense, an atmospheric sense perhaps, sort of gives us a sense of the national mood or what the country may be concerned about. And it would seem to me, again, just on the human level, that has to influence how, or at least...
Well, I think, you're putting your finger on a very important question, because the justices will say, well, we are only going to decide the case based on the law in front of us. A lot of these come up in terms of a statute or a provision in the Constitution. For example, a few years ago we had the question of, does it violate religious rights in the Constitution to have the phrase "under God" in the Pledge of Allegiance? It came from the father, who happened to be atheist, of a little girl in California who every day she went into her classroom and with her classmates was asked to pledge allegiance to the flag, one nation under God. We all know it, we all remember it since the mid-50s when that phrase was officially put in. And what he argued was that as an atheist, his religious rights were being violated. That was one question that I have to say washed out at the Supreme Court, because it turned out the justices didn't rule on the core question of the phrase "under God" in the pledge, whether the father did not have legal custody of the child.
That's exactly.
So, I almost hate to admit how many times, the justices end up having to take a pass or to punt in some way because because the question isn't quite framed correctly. But that just means that these issues just keep returning and returning to the Supreme Court.
As indeed they do.
Right.
Let's talk a bit, Joan, about how these two gentlemen, these two remarkable men, Senator McCain, Senator Obama, might, if either, well, one of them is definitely going to be president, and how they might proceed in making their choices. This also may be a reflection of how different they are as people. I've heard that Senator McCain either has or may constitute a kind of advisory committee to help him with a choice, and that it's, I suppose, rumored or suggested that former Solicitor General Theodore Olson might be key in that process, or advising him, or in any by any stretch of the imagination, there may be a group that he turns to help him make his choice. And with Senator Obama, I don't think that kind of thing has been suggested, but he has been a constitutional law professor. So how do you see the two of them?
That's an excellent question, because they are very different. First of all, Senator McCain has been around for a long time and has never made judges that big of a deal to him. It's never been a high agenda item for him as a senator of the United States. He was part of something called the Gang of 14 a few years ago that actually brokered a deal that sort of lowered the pressure on judicial nominations and helped strike a compromise between the two parties so that some of the lower court nominees of the current president, George Bush, could get through. He never showed a really intense stake in the issue, whereas Senator Obama happened to be president of the Harvard Law Review. In fact, he was the first African-American president of the Harvard Law Review. As you noted, George, he did teach constitutional law. A lot of his friends are constitutional law professors. John McCain, I know, is already relying on a team of legal experts, legal professionals who very much know constitutional law and have a certain stake in how they would like the court to go. And I'm sure he would rely on those people for advice should he become president and have an opening. Barack Obama, he's very good friends with a couple of high-profile law professors, Larry Tribe from Harvard, Cass Sunstein from Harvard. You know, those people who have been involved in past nomination fights. And on that topic, Ted Olson, who you referred to, the former Solicitor General, who also actually argued Bush v. Gore for then candidate George Bush, has been very much involved behind the scenes on confirmation fights, too.
Yeah, you know, that's excellent information also, Joan. And you know what's fascinating about this? I've heard this again, I'm not sure where I heard it, but that Barack Obama has expressed admiration for the Warren Court, and particularly for what he perceives as Chief Justice Warren's empathy for people, you know, the circumstances in which they find themselves. So it's very fascinating. And of course, it quickly brings us to the question of who might some of the people be in the minds of these two gentlemen. I'm going to certainly rely on you for the answer to this, but let me suggest a couple of things, Joan, that I've come across in reading as pertains to, well, Obama, for example. I've heard it or read that people like Judge Sonia Sotomayor.
From the Second Circuit up in New York City.
A brilliant young Hispanic woman who was born and raised in public housing. Might be one. And then also Harold Hangju Ko, who's the dean of
the Yale Law School.
And it's interesting to me, Joan, that these, in addition to their remarkable professional characteristics, they also bring certain ethnic qualities to the court, which it doesn't have.
George, I'm going to answer those questions, but first I'm going to give a very big caveat. You can't believe how wrong journalists have been on this. In fact, it is shocking. We're all collectively wrong each time, and it has nothing to do with us being smart or dumb. It has to do with the timing of a nomination hearing. And if you had told me in 2001, 2002, after George W. Bush came on, that his two nominations to the Supreme Court would both be white men, two appointees to the Supreme Court would be white men, not the first Hispanic, not another woman, I would say, how could that be? Well, look what we have. And part of it was the failure of Harriet Miers. Part of it was that Alberto Gonzales, who he was once very high on, who became his Attorney General and then became just sort of, you know, collapsed in scandal on many, many fronts. He was not even, you know, on the short list toward the end. So that is just to say there are many predictions out there, and we have been proven wrong, and the presidents have been proven wrong. President Bill Clinton, when he was campaigning, said he wanted to put Mario Cuomo on the Supreme Court, the former governor of New York.
That too.
Well, when the nomination came open, when Justice Byron White announced his retirement in 1993, President Clinton went to Mario Cuomo, and Mario Cuomo said, don't want it. And that's how he ended up with Ruth Bader Ginsburg. So all those caveats aside, I think somebody like Barack Obama, if he were to become president, would definitely want to make some sort of statement with diversity on that bench. Right now we have only one woman left on this 9-member court. We have one African American. We've never had an Hispanic on the bench.
Never had an Asian.
No, exactly right, exactly right. And you know, the individuals you mentioned, Judge Sotomayor, Dean Coe, Dean Elena Kagan from Harvard Law School. They're all people who I would think would definitely be in the mix. I just have no idea which way it would go. And the other thing depends on also who would leave. If Ruth Bader Ginsburg suddenly left and we were faced with a possibility of not a single woman on the nation's highest court, I don't see how a president wouldn't name a woman. But then that's what I said when George Bush came in. So that's what I say. But can you imagine nine justices up there and all of them being male? I can't. But you know, that said, strange things do happen in nomination fights.
Well, as always, Joan, your candor is appreciated. But so is your wisdom, because I think you're far more right than wrong. But you are absolutely right. Timing is going to dictate who's up and who's not. Just to be fair, in terms of the two men contesting the presidency, who do you think McCain's, at least perhaps somewhat more obvious than less at this point, choices?
Sure, on his short list, well, I would name right away a woman by the name of Maureen Mahoney.
Now, she's in private practice.
She is. She's a litigator, and she has a lot of the same experience that John Roberts had. She never ended up on a federal bench. The first George Bush wanted to put her on a federal appeals court, and her nomination was never brought up by the Senate, but she had worked for the Solicitor General's office, as John Roberts had. She's a very good oral advocate, has been up to the Supreme Court a lot, obviously a prominent female that, again, if there's an issue of a female coming on the bench. You mentioned former Solicitor General Ted Olson. Now, Ted Olson is in his mid-60s, and as I said earlier, Republicans tend to like them young. Somebody from that category of a former government lawyer might be Paul Clement, who was the very able Solicitor General under George W. Bush, who earned respect from lawyers of all ideological stripe and politicians, and so he could be a possible candidate also. I think that if it were a Republican president, if it was John McCain, there's a very, very full bench right now of Republican appointees in the lower courts that the Democrats just don't have, because we've just come off of 8 years of George Bush.
Well, you bring me right to the point where I wanted to be, and that's the appellate court, and talking about that, because we've handicapped to the best of our ability the possible entries in the horse race, but there is the context of the appellate court system, in which I understand, Joan, there's something like 12 vacancies perhaps right now, and of the, I think it's 167 justices who sit on it, most of them are Republican appointees. That's right.
Well, first of all, because we're coming off of, as I say, 8 years of a Republican administration, there are 12 regional courts. These are the courts right below the U.S. Supreme Court, and effectively they have the last say in the law of the land, because the U.S. Supreme Court takes fewer than 1% of the cases that are appealed up there. And these people have quite a hand in, as I say, setting the law in the country, the law that we all live under. And I'm going to mention a couple names that Ronald Reagan put on the appeals courts, more than 2 decades ago, who you hear of all the time still. Richard Posner, Frank Easterbrook, Edith Jones down in, the first two were from the 7th Circuit in Chicago, Edith Jones down in Texas on the 5th Circuit. These are people who were put on the appeals courts as young lawyers who have made such an impression on the law and such an impression on legal thinking. As I said, for conservatism. So if Barack Obama were to win and start a shift in the federal appeals courts, I think it would really change how many cases were decided and could start a pattern in the other direction. Those courts are very powerful, even though they don't get any of the attention the U.S. Supreme Court gets.
Yeah, that's extremely helpful. What kind of court is this right now, Joan? I mean, we could devote an entire program to that, and probably should at some early point. You're always welcome here, so that we can settle on that. But just in a brief answer, I mean, what has Justice Roberts wrought? I mean, has he? And I asked this bold question, and after having read the book about Sandra Day O'Connor and how she was such an anchor, a balance, a center of gravitas for the court, and she's not there now. What has he achieved with it? Is it
It's still so early, George, because we've had 2 full terms under Chief Justice John Roberts. In the first full term, it swung way to the right. It swung way to the right on abortion rights, on affirmative action, on campaign finance law. And in part it was obviously because of the kinds of cases that went up there. This year, in the most recently completed term, it was more of a mixed bag. I believe that the court under John Roberts is still going to be a fundamentally conservative court, potentially even more conservative than the court was under Chief Justice William Rehnquist. But you can feel these 9 people kind of trying to figure out where they're going. There's something that Byron White used to say, the justice who left the bench in '93. He said, with every new justice, you have a new court. Well, we had these 2 new justices in back-to-back succession in fall of 2005, and then in January 2006 is when Samuel Alito succeeded Sandra Day O'Connor. And I think they're all just sort of feeling their way. Right now, Justice John Paul Stevens is the leader of the liberal wing. If he were to leave, I think that would sort of...
How old is he?
He's the one who's 88.
88,
I think it would rejigger things too. Also, you take somebody like John Roberts, who is only 53, served on a lower federal court, but not for long. And I think he's still green in some ways. So just in a nutshell, a conservative court, a court that's deeply divided, a court that's struggling on some very important issues like church and state and abortion rights and race. And I think it's just going to take a few more years to really know definitively what they're going to do for the law.
Joan, we'll be watching, obviously, as citizens. It's the most amazing thing about these kinds of conversations with you, Joan, is that this is not just abstract, dry stuff that should send us non-lawyers scurrying. This is the stuff of our lives as citizens, and I certainly appreciate, and I'm sure all of our viewers do, the insights you give us.
Thanks, and just watch for the fleeting expletives before the mic.
I just love that. I'm going to use that for the fleeting expletives. It sounds saucy.
Term of art, yeah.
Thank you, Joan.
Thanks, George.
And that's our program. We appreciate your comments, and you can reach us at dialogue@wilsoncenter.org. I'm George Liston, CA, and you've been watching Dialogue, a co-production of the Woodrow Wilson International Center for Scholars and MHC Networks. Dialogue is also on the MHC Worldview channel, which is available to public TV stations nationwide. For more information, go to www.mhcworldview.org. Please join us again right here next week, and thank you for watching this week. And thank you, Joan. It's really great having you here.
Thanks.
The Art of Conversation, Dialogue at the Woodrow Wilson Center features 20 years of dialogue, distributed by the Johns Hopkins University Press, www.press.jhu.edu.